The U.S. Department of Justice has been caught red-handed violating federal law, removing photographs of President Donald Trump from the Epstein Files just hours after their court-mandated release, then scrambling to restore them after getting caught. This isn't a bureaucratic mistake. This is potential criminal conduct, and the evidence is damning. Late Saturday night, December 20th, 2025, at least 16 files vanished from the Justice Department's Epstein database. Among them, File 468, containing photographs that documented Donald Trump's connections to convicted sex trafficker Jeffrey Epstein. The images showed Trump's photos prominently displayed on Epstein's personal desk, framed, treasured, kept close at hand by a man who trafficked underage girls for decades. By Sunday morning, after journalists noticed the disappearance and Democrats cried cover-up, the Justice Department quietly restored the files. Deputy Attorney General Todd Blanche appeared on television claiming the removal had nothing to do with President Trump and was solely about protecting victims. But the evidence tells a different story, a story of an administration breaking the very law its president signed, a story of selective concealment to protect the powerful, a story that could result in criminal charges under federal obstruction statutes. Tonight, we examine how the Justice Department committed what may be the most brazen violation of transparency law in recent American history, and why those responsible could face up to 20 years in federal prison. On November 19, 2025, President Donald Trump signed Public Law 119-38, the Epstein Files Transparency Act. The law was explicit. Not later than 30 days after the date of enactment of this act, the Attorney General shall make publicly available in a searchable and downloadable format all unclassified records, documents, communications, and investigative materials in the possession of the Department of Justice relating to Jeffrey Epstein. 30 days meant December 19th, not December 20th, not within a few weeks. December 19th, period. Section 4 of the Act specified exactly 5 categories of permitted redactions: clearly unwarranted invasions of personal privacy, child sexual abuse materials, information jeopardizing active federal investigations, images of death or physical abuse, and classified national security information. Most critically, the Act mandated all redactions must be accompanied by a written justification published in the Federal Register and submitted to Congress. Every single redaction required public explanation. This wasn't optional. This wasn't a suggestion. This was federal law. The Justice Department's own fact sheet, released Friday morning, acknowledged these requirements. Under what is being redacted, it stated, "The Department of Justice is committed to transparency and redacting only what is legally required. No redactions have been or will be made to protect famous individuals or politically exposed persons." That promise would be broken within hours. But before we examine what the Justice Department did, we need to understand what they were required to release and what they're still hiding. The Transparency Act demanded disclosure of flight logs and travel records for any aircraft, vessel, or vehicle Epstein used. It required names of individuals, including government officials, connected to Epstein's criminal activities. It mandated release of any immunity deals, non-prosecution agreements, plea bargains, or sealed settlements. Most explosively, it required internal Justice Department communications concerning decisions to charge, not charge, investigate, or decline to investigate Epstein or his associates. And it demanded all communications concerning the destruction, deletion, alteration, or concealment of Epstein-related documents. The Justice Department acknowledged possessing approximately 1 million pages of Epstein documents. On Friday, they released a few thousand pages, less than 1% of the total. CBS News found that more than 500 pages were entirely blacked out, every single word redacted. Thousands more contained heavy deletions. Names of powerful individuals connected to Epstein, redacted. Internal DOJ communications about prosecution decisions, redacted. Documents concerning destroyed or concealed evidence, nowhere to be found. Where were the written justifications published in the Federal Register as the law required? They didn't exist. The Justice Department simply ignored that provision of the law entirely. Representative Thomas Massie, the Republican co-sponsor of the Transparency Act, put it bluntly on CBS Face the Nation. The DOJ is flouting the spirit and the letter of the law, but the violation of the December 19th deadline and the unlawful redactions were just the beginning. What happened next may constitute federal crimes. Friday afternoon, as the Epstein Files went live on the Justice Department's website, journalists began downloading and cataloging the material. Among thousands of photographs documenting Epstein's connections to the powerful and famous, one file stood out, File 468. The first image in File 468 showed a wooden desk or credenza from one of Epstein's properties. On its polished surface sat numerous framed photographs, a gallery of Epstein's social connections and prized relationships. Among the framed photos, images of Donald Trump. One showed Trump at what appeared to be a social gathering with several women, at least one in a bikini. Another showed the well-known photograph of Trump with his wife Melania, Jeffrey Epstein, and Ghislaine Maxwell at a formal event. These weren't hidden photos discovered in some secret vault. These were images Epstein kept on display, framed, prominent, treasured. The photographs documented a relationship that Trump has spent years trying to downplay, claiming he wasn't a fan of Epstein and had minimal contact with him. But here was visual evidence that Epstein valued his connection to Trump enough to keep his photographs on permanent display. And that evidence was now public, downloaded by journalists around the world, destined for front pages and evening newscasts. For several hours, File 468 remained accessible. Then, sometime late Friday night or early Saturday morning, it vanished. The direct link to the file returned an error message. The photographs were scrubbed from the database. And the Justice Department, an agency that had just promised transparency and accountability, offered no explanation whatsoever. By Saturday afternoon, journalists documenting the release noticed the discrepancy. CBS News reported that at least 15 files that had been accessible Friday were now gone. The Associated Press confirmed 16 files had disappeared. The New York Times began demanding answers. File 468, the Trump photographs, was the most prominent among the missing files. But it wasn't alone. Other removed files included images of artwork depicting nude women that had hung in Epstein's properties. The Justice Department's silence was deafening. No press release, no statement, no explanation. The files simply vanished as if they'd never existed, except dozens of journalists had already downloaded them and could prove they had been there. Democrats on the House Oversight Committee posted on social media Saturday afternoon. This photo, File 468, from the Epstein Files that includes Donald Trump, has apparently now been removed from the DOJ release. Attorney General Pam Bondi, is this true? What else is being covered up? We need transparency for the American public. The political implications were explosive. Attorney General Pam Bondi is a Trump loyalist who defended him during his first impeachment. Deputy Attorney General Todd Blanche previously served as Trump's personal attorney, and now files featuring Trump had mysteriously disappeared from a database that was supposed to provide complete transparency. But the political implications pale in comparison to the legal ones, because what the Justice Department did may constitute a federal crime. Title 18, United States Code, Section 1519 states, whoever knowingly alters, destroys, mutilates, conceals, covers up, falsifies, or makes a false entry in any record, document, or tangible object with the intent to impede, obstruct, or influence the investigation or proper administration of any matter within the jurisdiction of any department or agency of the United States shall be fined under this title, imprisoned not more than 20 years, or both. 20 years. That's the maximum sentence for destroying, altering, or concealing federal records with intent to obstruct. The Epstein Files Transparency Act had made clear that all files must be publicly released. The Justice Department uploaded those files to a public database, making them official federal records subject to the Act's disclosure requirements. Then they removed them, concealed them without legal justification. Did they have intent to obstruct? Consider the timeline. The files featuring Trump disappeared within hours of release. The removal occurred under cover of a weekend, when media attention would be lower and congressional oversight absent. And the Justice Department offered no explanation until after journalists discovered the removal and Democrats began alleging a cover-up. Only then, on Sunday morning, did Deputy Attorney General Todd Blanche appear on television to offer an explanation. Speaking on NBC's Meet the Press, Blanche claimed, "When we hear from victims' rights groups about this type of photograph, we pull it down and investigate. It has nothing to do with President Trump." He stated the Southern District of New York had flagged File 468 because it showed unredacted images of women who might be victims requiring protection. But this explanation collapses under scrutiny. First, the Justice Department had 30 days and more than 200 lawyers to review these files before release. They acknowledged this in their own fact sheet. The Department of Justice has more than 200 lawyers working around the clock reviewing each individual file for release. This is an arduous process, as each document and photograph must be individually reviewed by DOJ and the Southern District of New York for potential redactions to protect victims or potential victims. If File 468 required review for potential victim privacy issues, why wasn't that review completed before Friday's release? Did 200 lawyers somehow miss these photographs during their around-the-clock review? Second, the photographs in File 468 don't depict anything illegal or abusive. They show adults at social gatherings. The women visible in the Trump photographs aren't engaging in any activity that would identify them as victims of crimes. There's no nudity, no apparent distress, Nothing that would constitute child sexual abuse material or evidence of trafficking. Third, and most damning, the Justice Department's own review, conducted Sunday after the files were restored, determined there is no evidence that any Epstein victims are depicted in the photograph. This wasn't a close call requiring extensive analysis. After review, the department concluded no victims were shown, which means the photographs never should have been removed in the first place. If no victims were depicted, what legal justification existed for the removal under the 5 categories permitted by the Transparency Act? None. Fourth, if victim protection was genuinely the concern, why did the Justice Department remove only 16 files? The release included hundreds of photographs showing women at Epstein's properties and social events. Many showed unidentified women. Many could theoretically raise similar privacy questions. Yet only 16 files were removed, and the most prominent one featured Donald Trump. The Justice Department posted a statement on Twitter Sunday afternoon. The Southern District of New York flagged an image of President Trump for potential further action to protect victims. Out of an abundance of caution, the Department of Justice temporarily removed the image for further review. After the review, it was determined there is no evidence that any Epstein victims are depicted in the photograph, and it has been reposted without any alteration or redaction. This statement raises more questions than it answers. If the Southern District flagged the file for potential further action to protect victims, but review determined no victims were depicted, what further action was contemplated? What exactly was the SDNY concerned about? And why did this statement come via Twitter rather than through official Justice Department channels? Major legal decisions, especially those involving compliance with federal transparency laws, don't typically get announced through social media posts. The statement's phrasing is telling. The image was flagged for potential further action to protect victims. Not because victims were depicted, not because victim rights were violated, but for potential action. This is the language of preemptive censorship, not victim protection. By Sunday evening, File 468 was back online, exactly as it had appeared Friday, with no redactions. The review that supposedly required removing the files for victim protection concluded that no redactions were necessary. So why were the files removed? The only thing that changed between Friday and Sunday was public awareness. On Friday, the files were released quietly as part of thousands of pages of documents. By Saturday, journalists had spotted them and were preparing stories about Trump's photographs being displayed in Epstein's home. By Sunday morning, Democrats were alleging a cover-up and demanding answers. Only then, only after getting caught, did the Justice Department restore the files and offer explanations. This pattern is consistent not with good faith victim protection, but with damage control after an attempted concealment was exposed. But let's examine an even more disturbing possibility. That File 468 was removed not to protect hypothetical victims, but to conceal evidence of Trump's relationship with Epstein. Court documents released as part of the Epstein Files include testimony from victims describing encounters at Epstein's properties. One document, marked confidential and filed in Case 115CV-07433, contains testimony from a victim describing sexual encounters involving multiple individuals at Epstein's New York mansion. The testimony includes specific allegations involving Donald Trump. The victim describes being trafficked to Trump, detailing alleged asexual contact that occurred at Epstein's property. The document references emails, flight records, and communications with Epstein's assistants Sarah Kellen and Leslie Groff, precisely the kind of documentation the Transparency Act required be released. These allegations aren't new. They've been public for years through civil litigation, but they've never been confirmed or substantiated through release of the underlying documentary evidence. The Transparency Act mandated release of flight logs, email communications, and internal DOJ documents that could corroborate or refute such claims. Where are those documents? Where are the flight logs showing who traveled to Epstein's properties and when? Where are the email communications between Epstein's staff and individuals in his network? Where are the internal DOJ memos discussing these allegations and decisions about whether to investigate? The Friday release included heavily redacted flight logs with most passenger names blacked out. It included photographs, but little documentation of who attended which events and when. It included no email communications between Epstein's operation and powerful individuals in his network. In other words, the Justice Department released the least incriminating material while withholding the most substantive evidence, precisely the opposite of what the Transparency Act required. Could the Trump photograph removal be connected to concerns about what other evidence might emerge? Consider what File 468 actually shows. Photographs of Trump prominently displayed in Epstein's home, suggesting a relationship Epstein valued and wanted to memorialize. If Epstein valued this relationship enough to display photographs, what other documentation might exist? Correspondence, phone records, guest logs showing Trump's visits to Epstein properties, flight records showing travel on Epstein's aircraft? The Transparency Act required release of all such documentation, but it's conspicuously absent from Friday's disclosure. Representative Ro Khanna, the Democratic co-sponsor of the Transparency Act, stated the problem clearly. It's not about the timeline. It's about the selective concealment. Selective concealment, that's the phrase that matters. Because if the Justice Department is selectively withholding documents related to Trump while releasing documents related to others, that's not victim protection. That's corruption. And that brings us back to 18 U.S.C., paragraph 1519. Whoever conceals federal records with the intent to impede, obstruct, or influence proper administration faces up to 20 years imprisonment. The Trump administration has now created a situation where senior Justice Department officials, including Attorney General Pam Bondi and Deputy Attorney General Todd Blanche, could potentially face criminal exposure. Representative Thomas Massie announced he's exploring inherent contempt proceedings against Attorney General Bondi. This would give the Attorney General 30 days to release all remaining documents. After that deadline, Congress could impose daily fines, potentially escalating to more severe penalties, including detention. Representative Jamie Raskin stated Democrats are exploring all legal options, including litigation, to force compliance and potential criminal referrals for obstruction. But the most serious threat may come from an unexpected source: career prosecutors and FBI agents who have spent years investigating Epstein and Maxwell. Multiple Justice Department whistleblowers have contacted congressional offices expressing concern about political interference in the Epstein Files release. These career officials, who risked their careers to investigate Epstein when powerful people wanted the case buried, are watching as their work is selectively disclosed to protect political interests. One whistleblower, speaking on condition of anonymity to news outlets, stated, "We were told to document everything about Epstein's network. We did. Now that documentation is being buried to protect people who should be exposed." Another noted, "The Transparency Act required release of documents about who knew what and when. Those documents exist. They're being withheld because they're damaging to powerful people, including people in this administration." If career Justice Department officials conclude that political appointees are violating federal law to protect the president, they have legal obligations to report that conduct. And if they fail to do so, they themselves could face liability as accessories to obstruction. This creates a pressure cooker situation. Career officials must choose between loyalty to political leadership and compliance with federal law. And every day they remain silent makes them more complicit in the violation. For survivors of Jeffrey Epstein's abuse, this entire debacle represents another betrayal in a decades-long series of betrayals. 18 survivors issued a joint statement calling the Justice Department's handling a slap in the face. Maria Farmer, who reported Epstein to the FBI in 1996, stated, "If the government had done their job 30 years ago, 1,000 victims could have been spared." But now, even after Epstein's death and Maxwell's conviction, the Justice Department continues to protect the powerful at survivors' expense. One survivor, identified as Jane Doe, discovered her name appeared multiple times in the released files. Inadequately redacted, now public, her privacy destroyed. She had reported her abuse decades ago, expecting protection. Instead, she got exposure. Meanwhile, the names of powerful men in Epstein's network remain carefully redacted. Their privacy is protected while survivors are exposed. The message couldn't be clearer. If you're powerful, connected, and wealthy, the Justice Department will break the law to protect you. If you're a victim, you're on your own. This is the reality of American justice in 2025, and it's documented in the Epstein Files, or rather in what's missing from them. The Epstein Files Transparency Act set a clear deadline, December 19th. That deadline was missed. The act required release of all unclassified records. Less than 1% has been disclosed. The act mandated written justifications published in the Federal Register for every redaction. None have been published. Most damningly, the act prohibited removal of released files, but 16 files were removed, including photographs featuring the president, then quietly restored only after the removal was discovered and challenged. Every one of these actions constitutes a violation of federal law, and some, particularly the removal and concealment of File 468, may constitute federal crimes under obstruction statutes. Deputy Attorney General Blanche told NBC, "Bring it on," when asked about contempt threats. That bravado may prove short-lived, because bringing it on means congressional subpoenas demanding every email and communication about the File 468 removal decision. It means Inspector General investigations into who ordered the removal and why. It means potential criminal referrals if evidence suggests obstruction. It means survivors filing federal lawsuits under the Crime Victims' Rights Act, demanding the transparency they were promised. It means ethics complaints against Justice Department officials who participated in the violations. It means career prosecutors and FBI agents potentially becoming witnesses against their political leadership. Most significantly, it means the permanent destruction of this administration's credibility on transparency and accountability. President Trump signed the Epstein Files Transparency Act, presenting himself as the only leader willing to expose Washington's secrets. The Justice Department's fact sheet proclaimed, "The Trump administration is continuing its unprecedented support for Epstein transparency." That claim now lies in ruins. The administration that promised transparency delivered concealment. The Justice Department that swore to protect victims protected powerful men instead. The officials who pledged to follow the law broke it brazenly and publicly. And the evidence of their violations is preserved forever in the files themselves, both in what was released and what remains hidden. File 468 is back online now. Anyone can view the photographs of Trump displayed in Epstein's home. But everyone knows those photographs were removed, concealed, and restored only after the concealment was discovered. That attempted cover-up tells a more damning story than any photograph ever could. It reveals an administration so committed to protecting its leader that it will violate federal law, risk criminal prosecution, and betray survivors of horrific abuse. The Epstein Files were supposed to provide accountability. Instead, they've provided proof of corruption at the highest levels of the Justice Department. And that proof is now part of the public record. Impossible to remove, impossible to redact, impossible to deny. The only question remaining is whether anyone will be held accountable for breaking the law, or whether, as so often happens in America, the powerful will once again escape consequences while survivors are left searching for justice that never comes.